Here's what's really big to me. We feel that the difference between the sale price after taking into account an 85% ratio in the 2012 assessment, a difference of $917,660, adequately accounts for going concern, business value, goodwill, or other intangible items that you report to be included in the sales price. I would also like to point out that the commercial properties are valued individually and do not use, she goes on to say, do not use mass appraisals per se. So the county does seem to concede that going concern was factored in, but all they say is, this is what we feel. They didn't document anything. They haven't presented anything. So once again, their failure to account for going concern.
Emails?
Yes, sir.
Okay.
And for the record, that was not an email in response to evidence. It was an email in response to, hey, let's try to work this out and make a deal before I submit my
However,
Fair enough.
However, I did submit that email into the evidence
Yes.
packet.
Yeah.
Okay. I am speaking on behalf of my client here, who has pointed out that the 3 hotels are much higher name brand hotels. You will see here that it is assessed 138% above the average 2012 assessed livable area, that the income of this property, the PGI, is about approximately 56% higher on average between the 3 comps over my property, and yet they are assessed at substantially less. Their land, which is right there next to them, and these are superior chains, is assessed at an average of $4.73 a square, while my property is assessed at $9.16 a square, approximately double per square foot of land. Over these 3 properties have better views that can be seen from the road, that are name brand chains. I also want to point out the property appraiser's office also failed to properly consider geographical stratification. This property is on the border between Hillsborough and Pinellas County, yet their comps show not one sale from Hillsborough County. In the next case we'll have here in a few moments, the appraiser includes comps from all over the state of Florida. I do want to real briefly cite from a Department of Revenue publication, Informational Bulletin PTO 0929, materials describing the general appraisal practices of the property appraiser alone, without discussing how those practices were applied to the assessment at issue, are not sufficient to establish a presumption of correctness for the assessment. Now I'm just hearing of that they have identified certain comps as being more weighted than others. This was not presented to the petitioner. All they seem to have is general averages, and this seems to be somewhat of a general printout. So any custom information for this property was not presented.
But didn't you're looking at the sale prior to the renovation?
No, sir, because the lien date is January 1st. Therefore, and that sale with that listing was from early December, and it was marketed long before that. But it actually closed in early December. So those renovations were done at the time of the lien date.
Okay.
So
they're using it as a sale then, right?
yes.
As of...
But they're using it as a land cost, so they're doing the extraction. And where they went terribly wrong is they have this landmark building completely renovated in 2009 as being worth $22,000. Therefore, artificially inflating the land value to 54 square. You'll notice there are 2 others, which were poor comps to begin with, are at 32 and 38. And if you factor in the 8 criterion, our property is assessed at 40 a square. So the only way they were able to jack it up was by writing this building off, this landmark, completely remodeled building off, as being only valued at $22,000. Which, once again, bad data. So even if the extraction method is valid, that's very bad input. And by their own admission, their other 2 comps are valued what the cost of sale. We're looking at like 28 and 34, 35 bucks. Okay, let's see. Rebuttal evidence. The taxpayer initiates have an exchange with the property appraiser. Reed, while I go on with this, I'm gonna say it, and then it'll be up to the appraisers. Will you please go through and there's 3 examples of taxpayers' rebuttal evidence. Find the one. It says something along the lines of before the hearing it has to be submitted. And once again, the appraiser's office, they sent it to me right at their deadline. I'm booked with cases and running 3 businesses. So, I wish I had more time. If the county had provided me with their packets earlier, I would have had more time to submit it to them in advance. In either case, they failed to consider one of the criteria, which is the income of said property. Furthermore, the income of the property, as described by the owner here, comes from occasionally renting out boat or slips for trailers, parking space, extra fees from parking at events. In December 2011, approximately $100. Parking fees from major festivals held at John's Pass. Average annual income from parking amounts to about $1,000 plus extra income. So this is in fact an income-producing property. And Hep, can you...
Again, I object.
Thank you. And may I read from the...
It's going on record because he's reading it in, and it was not presented, and I did not see it until today.
Okay, can I read what the Value Adjustment Board Training Module number 4 has to say, citing the Department of Revenue handbook here? Under rule, these evidentiary materials shall be considered timely under either of the following two conditions. If the evidentiary materials were provided to the property appraiser no later than 15 days before the hearing in accordance with the evidence exchange, if provided to the property appraiser less than 15 days before the hearing, the Board of Special Magistrate determines that evidentiary materials were provided at a reasonable time before the hearing. If a petitioner has acted in good faith and not denied evidence prior to the hearing, but wishes to submit evidence at the hearing which is of nature that would require investigation or verification by the property appraiser, then a special magistrate may allow the hearing to be recessed and, if necessary, rescheduled so the property appraiser may review such evidence. See Rule 12D-9.025, paragraph 4, section F, etc., etc. This is Rule 12D-9. Yeah, oh, there you go, Ms. LeBlanc. As a tier of fact, the Board of Special Magistrate may independently rule on the admissibility and use of evidence. Last year when I sat before the magistrate, I didn't know that you couldn't admit 2012 comps, so my comps from March and April were not only not considered, but they just said save them, don't submit them, we're not going to accept them. If the Board of Special Magistrate has any questions, they can consult the attorney as to the admissibility. The basis for any ruling on admissibility of evidence must be reflected in the record. I requested that be done. It does mention you can delay ruling until you consult with the board's attorney. I didn't want to go on to point out that it also mentions that property owner generally is qualified on account of ownership to testify regarding the just value of his or her property. And this is in reference to 342 B.R. 861. So the first point I'm going to make is it was built in 58, yet the county has an effective age of 26 years. Once again, this is a dilapidated building, and I've documented that pretty well here. You can see breaks in the pavement, staining, the paint's completely chipped away. It's just an all in all very poor condition.
I just point out that those are the qualification requirements of the property appraiser with respect to qualifying or disqualifying sales to the Department of Revenue. It doesn't apply to petitioners. It just doesn't apply. It's not. It relates to their standards of reporting for the property value rule. So I think he read it correctly, and he talked about to the department and said he didn't receive the same analysis that this is a reporting requirement to the Department of Revenue, which he is not.
Not yet.
I mean, certainly, he can ask for explanations, and I think Charlie.
But I'm sorry. What are you basing that on? That is, I've given you my citation, but can you
Transaction data for each sale shall document the disqualification in a manner prescribed by the department, and the department will randomly. It's for their reporting. And then again, it's for their. I mean, I think it's when they are qualifying or disqualifying the sales in their system. Maybe you could, but you're talking about your sales. They're not their sales. So this requirement applies to a property appraiser when they input into their system sales is qualified or disqualified when they come through.
So it's your opinion that the appraiser's office has no obligation to provide any documentation if they want to claim that a taxpayer's sale is a proposed sale is disqualified?
If they want to rebut a sale that you present, I don't believe this rule requires them to give you some sort of...
or the magistrate?
Well, I think if they don't give it to the magistrate, then again, the magistrate may not accept what they say.
Well, there we go.
Certainly, but I just want to make the distinction that you're saying they're not following a rule, and the rule applies to when they are qualifying or disqualifying the sales in their system, not rebutting and hearing the sales that are presented by the petitioner. Certainly, again, the special magistrate may feel like without any further documentation they don't believe the property appraiser's office, but that goes against the weight of the evidence. But to just say that we're not following rules,
I contend with that interpretation of the statute. That is, why should they be exempt from it for the taxpayer and yourself, the magistrate? So they haven't documented any disqualifications. Well, yeah, I combined several of the pages. So
Well, that's the problem. You submit them to me as one page, and you're presenting them as a packet.
well, sir, I can take the staple out if that's your concern.
No, I'm just saying I need to verify what's
Why don't
here.
you separate it and
I'll take
give
the
it to
staple
it?
out.
Well,
This is the way
just
you
give it to them the way it was.
You presented
and
us the
maybe
way
it'll
they're
speed up
stapled here,
things.
so.
Well,
Do we have a staple remover?
Just, you know what, just let me flip through it.
sure, sure.
I think he just-
I think are we admitting the staple? No?
No,
Okay, all right. Well,
that's there for common use.
I'm going to, so I can't keep the staple on it?
No, you can keep the staple, we just want to.
Because I have a paper clip.
We want to keep the pages in the
Yeah,
same
you,
order.
you can submit anything you want, but we have to be able to refer to
With
it.
the following.
Only take on cases in which I do a thorough pre-qualification and make sure that's a slam dunk case, essentially. That is, I look at some relevant data, and otherwise, frankly, I don't take the case. For example, it's normally on a property assessed at this amount not feasible for me to physically go on site and inspect every unit, etc. However, this particular property happened to have a liquor store in it. It was 6 p.m. on a Friday night, so I decided I'd drop in and check it out, just to do a little extra due diligence here. And what I saw was the store, they weren't expecting me, so the store owner was kind of surprised, but I'm going to show you pictures of the only unit I could get inside. The only other unit open there when I stopped by was the bar next door. And I was pretty sure I was going to get stabbed or something if I went in there, so I decided not to stay
I
out.
guess it depends how you were dressed.
Yeah. I wasn't donning a tank top, unfortunately.